Thanks for staying with us again. My name is Les McFadder with the law firm of Perry & Young. This is Law Call. We are answering questions live on the air regarding personal injuries. If you want to give us a call, the number is 850-392-1544. You can send us an email at lawcall@wmbb.com. And we actually have an email that came in over the break, email from Jason. Let's go ahead and put that up. Okay, Jason says, if someone is killed but they don't have any immediate family, no wife or kids, parents are deceased, who would be legally allowed to file a lawsuit on their behalf? And again, that's from Jason. Jason, that's a great question, and it's one unfortunately we have to deal with quite often. And what I think people are probably going to realize when they hear the answer to this question is, there's a lot of things about the law that people may think are pretty unfair. And when it comes to wrongful death cases, there are some very strict limitations on who can bring the claim and who is entitled to recover for certain types of damages. So, Jason, to answer your question, a person dies, the only person in the state of Florida that's allowed to bring a claim is called the personal representative. The Wrongful Death Act is codified in a Florida statute. It spells out who is allowed to bring a claim and who is allowed to recover for the death, the types of damages they can recover. In this situation, if the person dies and they have no spouse and they have no kids and their parents are deceased, then the only entity, if you will, that is entitled to recover anything at all is the estate of the deceased person. And those damages are limited to net accumulation, so basically how much you would have earned over your lifetime minus what it would have cost you to live, and burial expenses, cost to bury you. That's essentially all you're entitled to recover, which, somebody blows a red light, they're DUI, they take somebody out, that person is single, no kids, parents are passed away. Even though that person had a life, they had a job, they had friends, the only claim is going to be for that person's net accumulations, which, depending on what you do for a living, may not be a very high number, and the cost to bury you, which you're talking usually a few $1,000s for a basic burial. So there's really not a lot of damages that can be sought whatsoever, but medical malpractice cases, we see it quite often as well. And so what's the difference in medical malpractice? We have this thing that we refer to as the free kill law, and people are like, free kill? In medical malpractice cases, if somebody dies as a result of medical negligence and they're not married and they have no kids and they have no parents, what, Brian?
Well, it's the exact same thing. If a doctor makes a mistake and were to catastrophically injure me and kill me, my parents wouldn't be able to pursue anybody because I'm not married and I do not have any kids. They aren't survivors under the Wrongful Death Act and the Medical Malpractice Act in Florida. One of the two things I'll mention, this is Florida specific, who can pursue claims. It's very state specific.
So
I know you're licensed in Georgia. So
Georgia's different, Alabama's different, but for Florida claims, yeah.
What the estates are entitled to is another thing. And one thing I know I ran into with a great family who lost somebody last year is the decedent, the man, was not technically legally married to his wife who he had been with forever. And so someone who is together with somebody but not legally married, can they pursue a claim in Florida?
It really just depends. I mean, there is a little bit of a carve out with these longer relationships. If you support somebody, if they're like you were a primary supporter of somebody, they relied upon you, that person may have a claim for support and services. But beyond that, the Wrongful Death Act is very specific as to who can collect in these sorts of things. Now, if you have children, they can collect for their pain and suffering and their loss of companionship, loss of parental guidance, things of that nature. If you have a spouse, the spouse can obviously recover for their pain and suffering, their loss of companionship if somebody dies. If you don't have a spouse and you don't have kids, but your parents are alive, as long as it's not medical malpractice, your parents can recover in that situation. But if it's medical malpractice, they can't. There's a little bit of a carve out. So
just to interrupt you there, so in your situation, if you were to be killed by a driver, your wife and kids and parents can or can't all pursue together, or is it limited there?
My wife and my kids. The wife and kids. I mean, it's kind of an either or. Your wife can, your kids can. If you don't have a wife or kids, your parents can. But again, that medical malpractice carve out for healthcare providers If there's no wife, there's no kids, there's no spouse, there's no kids, most of the time there's no claim, or if there is, it's very, very, very minimal. And when you balance that with medical malpractice claims and the cost that it takes to advance those sorts of claims, Florida doesn't just allow you to go and sue a hospital or sue a doctor. There's a very extensive pre-suit investigation period that you have to go through first. You have to identify, number one, was there a medical mistake made? And I'm talking specifically medical malpractice. Did the doctor make a mistake? Doctors,
which is different from just a bad result.
right, not, bad results happen. There is a risk with every sort of a procedure. They give you this long list of things that this could happen, and those are known risks. And so we're not here to suggest that doctors should be perfect or hospitals should be perfect, because we know that's an impossible standard, and we can never have that in this society. But if a doctor makes a mistake that then creates a very, very bad outcome, well, first we have to get all the medical records. We have to have those records independently reviewed by a physician that is in the same practice area as that doctor that we think made the mistake. They have to look at all the records. They have to look at what the doctor did. They have to then author an opinion in an affidavit format that says, yes, the standard of care was breached. Here's how it was breached. Here's the mistakes that were made. This is what the doctor did or didn't do. This is what they should have done or didn't do. And then now you have your corroborating evidence that you can then go and present it to the hospital, present to the hospital or the doctor, and then there's usually some sort of discussions pre-suit, but then at that point you're allowed to file a lawsuit. So there's a lot of times you do these evaluations by these physicians, and they come back to you and they say, yeah, terrible result, but it's not a breach of the standard of care. The doctor did everything they're supposed to do. Sometimes things happen, infections happen. Bad results or bad reactions to anesthesia happen. If it is a known risk, it is something that, despite the best efforts, there was just a bad outcome, that may or may not rise to the level of medical negligence. And if it doesn't, you go through this whole analysis and the expense of getting this information, and the doctor comes back and says, you don't really have a case. There's no breach of the standard of care. That happens much more often than what people think.
Yeah.
And so, somebody that does this type of stuff all the time, and you hear people make these offhand comments like, frivolous lawsuits, that's why our health care is so expensive. People have no idea the number of cases that we review on a regular basis that we just look at and we go, this is a bad result, but there is just no legal liability. It vastly outnumbers the cases that we actually end up bringing. If we bring a medical malpractice case that makes it into suit, there's a pretty good chance there's some meat on that bone.
And the other thing is we do have doctors who do make mistakes and they commit malpractice, but the injury just isn't there or it's fixed.
Right.
So in those situations, we can't go spend $10, $20, $30, $40,000 to go investigate the claim when the case is worth $10, $20, $30,000.
Or if the outcome, like you said, was fixed. Somebody goes in, they have orthopedic surgery and a nail breaks off and something happens, they have to go back in and get a revision, and then the doctor goes in and says, oh, look at that, and they fix it and they sew them back up, and there's a little bit of a delay, but 6 months, 12 months down the road, 2 years down the road, it's the exact same outcome. Was there a mistake? Potentially.
We could say there's a mistake, but it's been corrected.
But it's been corrected, right.
The injury isn't bad enough for us to go invest the money that is required by Florida law to go pursue the malpractice claim.
Because the recovery was turned out to be okay. And we have to look at those sorts of things because, the only thing we have our time and we have our resources that we put into investigating cases. It is absolute foolishness to go and throw your time and your money away at chasing frivolous claims because frivolous claims aren't worth anything. They are frivolous by definition.
Yeah.
And so we try to be a very good steward of our time and our resources and avoid filing those types of claims because at the end of the day, it's just bad business.
It's bad business and it doesn't help anybody.
And it's unethical.
Any side.
It's unethical.
Yeah.
I mean,
that's our starting point.
That's the first. I mean, if it's unfair, unethical, we're not going to do it. So, just something to think about. There's a lot that goes into evaluating these sorts of claims that a lot of people just don't realize. But when you're in the business, you see it every single day, and sometimes, people just don't know.
Yeah, and I think our starting point is generally what I tell my clients. They always come in, they are in a car wreck or something, they're asking, do I have a claim? So for us, there are a couple of slight exceptions with dog bites or products, but if somebody did something wrong and caused you harm, the starting point is you have a claim. Now, whether that claim is worth $500 or $10 million, we don't know until we actually evaluate and investigate it.
Right.
But that's kind of our starting point is, did somebody do something wrong, unreasonable, negligent, and cause somebody else harm? And if so, yes, you have a valid claim. It just kind of depends.
Right. Very good.